My name is Catherine Morris from Lawyers' Rights Watch Canada, and I'm here with Robert Morales. And thank you, Robert, for welcoming us to the Ho'okaminam territory. Robert is going to talk to us about the very interesting decision of the Inter-American Commission of Human Rights to accept the petition of the Ho'okaminam Treaty Group, which alleges that Canada has violated the American Declaration of the Rights and Duties of Man by failing to resolve the Ho'okaminam Treaty Group's land claims, or land disputes, we prefer to say. This is a precedent-setting decision that was made just over a year ago, on October 30th of 2009, which ruled that the petition could proceed without the necessity of the Ho'okaminam Treaty Group exhausting its domestic remedies in Canada. And so we want to be very thankful to Robert for speaking to lawyers and others in Canada about this groundbreaking decision and the history of it.
Thank you. Thank you, Catherine. Squale Siempsea. We are happy to have you here in our traditional territory today. My traditional name is Tl'ul'thut, and I'm known as Robert Morales. I'm the chief negotiator for the Ho'okaminam Treaty Group. The Ho'okaminam Treaty Group has 6 member nations, the Cowichan tribes, the Lake Cowichan First Nation, the Penelakut tribe, the Tl'ul'thut First Nation, the Liaxin First Nation, and the Seminas First Nation, which is where we're located and where we're making this presentation today. As Catherine has said, the Ho'okaminam Treaty Group has been involved in the BC treaty process since the beginning. So we have been at the treaty negotiating table here in British Columbia for the past 17 years. And as a result of being at the table, we have hit a major obstacle, which is why we have decided to take our case outside of Canada. And so I'll be discussing that here this morning as we go through this presentation. I've entitled this presentation, International Human Rights and Indigenous Peoples, Linkages to Domestic Aboriginal Rights. We know that in Canada, under the English common law, that the domestic, that is the Canadian legal system, does have provisions which recognize Aboriginal rights. We know that there was constitutional reform in 1982. At that time, Section 35 was included in the Canadian Constitution. Section 35 states that there is a recognition of Aboriginal rights, and as well, we also have the Royal Proclamation of 1763, which is another constitutional document. Both of those recognize Aboriginal rights and really mandate the government of Canada and Canadians to be able to deal with those rights. But what we see since 1982 is what we've described as an implementation gap. That there has been a history of denial up until 1982 that Aboriginal title exists in British Columbia and that Aboriginal rights exist. We know up until the Calder decision before the Supreme Court of Canada in the 1970s that there was a denial that Aboriginal title existed in the province, and Canada and British Columbia argued that in fact it had been extinguished by colonial and subsequent legislation. That attitude seems to continue through to today. And as a result of that, we see that the treaty discussions in British Columbia really haven't moved significantly, that we have 2 treaties after some 17 years of negotiations. We see that there's an implementation gap in terms of common law judicial rulings. So we have, starting with the Calder decision, we then move forward to the 1980s, where the Delgamuukw decision was rendered by the Supreme Court of Canada, and then we have the latest decision, which is the Roger Williams or Joe Coton decision out of the British Columbia Supreme Court, which is on appeal now. Those rulings of all were put forward by First Nations, Indigenous peoples, in an attempt to have recognition of their title. All three of those rulings failed in terms of that, and so there has been no decision in British Columbia issuing or making a declaration that title exists and issuing a ruling that it has to be the state has an obligation to title lands. We also see in the treaty process that there's an implementation gap. As I say, we've been negotiating for 17 years. In British Columbia, we have 3 treaties at the current time: the Niska Treaty, the Tl'ul'thut Treaty, and the Maynooth Treaty, which are the only 3. So there are still large outstanding issues that need to be dealt with. We also see that there's gaps in legislation and policy, that this history of denial that has existed in British Columbia continues through to today. This slide here is, I think, an illustration of that. At the G20 conference in 2009, the Prime Minister, Stephen Harper, claims that Canada has no history of colonialism. Well, we know that that is in fact not true. So when we look at the international area, and that's the other legal system, so we have the domestic legal system and then we have an international legal system. So I've just kind of outlined very briefly the domestic legal system, and particularly the constitutional provisions that we have here in Canada. There's also international treaties, and under international treaties, the executive branch has the constitutional jurisdiction to enter into those type of treaties. The parliamentary branch really does not get involved. There's no, unless there's laws that are passed to implement particular treaties. So we see, for instance, the NAFTA treaty has legislative implementation of that treaty. And of course, the judicial branch can rule on the implementation. We say, and I think that it's certainly under international law, that any state that enters into a treaty has an obligation to honor those treaties. So Canada has an obligation to honor the treaties that they sign on to, including, as Catherine has said, the Organization of American States Declaration on the Rights and Duties of Man, which is really what we're going to be speaking of today. So in terms of the application of international law in Canadian domestic law, I have a couple of quotes here from 2 legal scholars on this issue. The first one, the quote is, "We know for certain that we do not know whether customary law forms part of the law of Canada." And the second quote is, "Within the international point of view, a sovereign state cannot invoke its internal law, including its constitutional structure, to justify a breach of its international obligations." So these 2 quotes then really do sort of state where we've been in terms of international law and how it applies within the Canadian, the current legal system in Canada. So when we look at that, we have the Regina versus Happ decision of the Supreme Court of Canada, which held that basically Canada has an obligation to honor its commitments that it has made through entering into treaties, international treaties, and that as also that the customary law forms part of the common law of Canada. So unless Canada explicitly says that these international customary laws do not apply, then the presumption is that they do apply.